Is there a maximum number of objections that an attorney can make during the course of a trial? Would you like to know the answer? Come join me on this walk as I share with you the answer to this question. Hi, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury attorney. The answer is no. There is no set limitation on the number of objections an attorney can make during the course of trial. Why is that? I'll tell you why. It's because an attorney has an obligation to go ahead and represent their client to the best of their ability. If there are things going on during the course of trial, I, as an attorney, have an absolute obligation to make my objection known to the judge. I have to voice that objection. And even if I'm wrong, I still have that obligation to go ahead and make that objection. Even if I get snickers or laughs from my opposing counsel, if I believe that something is being done wrong or incorrectly or against the current law that exists in New York, guess what? I have an obligation to my client to go ahead and preserve my legal rights, actually my client's legal rights. And the only way I can do that is by making an objection. So let's get back to basics and let's understand what an objection really is. So let's say you brought a lawsuit against your doctor claiming that he was careless. Your doctor denies all of the allegations. And now your case ultimately goes to trial. So 2 years down the road after you started your lawsuit, now your case finally comes up for trial. And during the course of trial, certain things are going on. The defense attorney is asking his medical expert certain questions that you believe are inappropriate. He's asking his expert leading questions. And now I get up and I argue, Your Honor, at this time, I object to the defense's questions. He's leading the witness. And in each instance, the judge is denying my request and he's allowing the witness to answer. Now, why do I keep jumping up and making these objections? Because there are certain rules that go on with these trials. And one of the rules is, listen, if I'm putting up my own expert to validate and confirm and justify our particular side of the case, I am not permitted to go ahead and ask leading questions in most cases. When it comes to establishing the doctor's credentials, I am permitted some leeway to ask leading questions. And you should know, what's a leading question? Where I basically put the words into my witness's mouth. Doctor, isn't it true that you graduated from this medical school? Now that only calls for a yes or no answer, right? I didn't simply say, Doctor, what medical school did you go to? That would be an open-ended question where I ask the doctor a question and the doctor is the one who answers. But where I simply say, hey, doctor, isn't it true you went to this medical school? Where it calls only for yes or no? That is a leading question. So there are instances like that where I believe something is being done incorrectly. And now I have an obligation to alert the judge, hey, judge, something's going on here that shouldn't be going on. Now, why is that a big deal? It's a big deal because whoever loses the trial now has to go ahead and appeal. And on appeal, there is no additional witnesses that are heard. There's no additional testimony that is reviewed. What happens? The appellate court, who is now evaluating this appeal, looks at the trial transcript. And if they do not see that the attorney has gone ahead and objected to a certain issue that came up during the course of trial, the attorney will have been deemed to have waived any issue that comes up because of that, right? That means that they lost the opportunity to appeal that issue. So that's why it is critically important for an attorney to actually make an objection at the time it is happening. You can't do it an hour later and say, oh, by the way, judge, this attorney asked a question that I should have objected to. I want it noted on the record. No, it doesn't work that way. If you want to preserve your right to appeal that issue, the attorney has to be present at that time and has to recognize that something wrong is going on and has to alert the court, hey, judge, there's a problem here. And he has to give the judge an opportunity to make a ruling that fixes the problem. Judge, I object. He's asking a leading question. And now the judge has to decide, is he correct or is he incorrect? And if the judge makes the wrong ruling, if he makes an error of law, now that may be a basis to turn over the verdict, to throw the original verdict out, and now to send this case back for a new trial. Why? Because the appellate court may decide that the judge made incorrect rulings of law and that made a difference in the outcome. It is critically important for an attorney to go ahead and object as it's happening. If he doesn't do it at that moment, he will now waives his right to raise that issue on appeal if he and his client have lost the case. So to go back to the title of this video, is there a limit or a maximum number of times that an attorney can make an objection? The answer is no. There is no definable limit or number of maximum times an attorney can object. He is obligated to make an objection in every instance that he believes that something significant is happening, that he needs to be addressed and corrected. And then, once the court is alerted to that problem, the judge then has to make a ruling, an immediate ruling, as to whether he agrees or disagrees, and now the case proceeds forward. So why do I share this great information with you? I share it with you just to give you a sense of what really happens in these medical malpractice cases in New York. You know, I recognize and I understand you're watching this video because you likely have questions or concerns about your own matter. Well, if your matter did happen in New York, but you have not yet started a lawsuit because you still have questions that need to be answered, what I invite you to do is pick up the phone and call me. You know, I answer questions like yours every single day, and I'd love to talk to you. You can reach me at 516-487-8207 or by email at Gerry, Gerry, at Oginski-law.com. Well, that's it for today's video. I'm Gerry Oginski. Have a wonderful day.